What if the most consequential decisions never happened in front of cameras at all? Not in interviews, not in speeches, not even in courtrooms. What if the real story unfolded quietly, behind closed doors, in the months before anyone knew to look, when the narrative still felt unsettled, when loyalties were fluid, and when preparation mattered more than proof? But before we continue, please subscribe and turn on the notification bell for updates. Because here's the contradiction that keeps pulling at this story. Publicly, what the world saw was chaos, confusion, emotion, a couple under pressure, an institution scrambling to keep up. Everything framed as reactive, messy, even accidental. Privately, according to a growing number of reports and allegations, something else may have been happening entirely. Structured, anticipatory, calculated. And if that's true, then the question isn't who said what on television. It's who was planning for the aftermath long before the cameras ever rolled. That's where this story begins. Not with Oprah, not with titles, not with exile or reconciliation or headlines screaming betrayal. It begins with silence. A particular kind of silence that institutions adopt when they stop speaking emotionally and start thinking procedurally. When meetings become smaller, when emails become shorter, when words like concern and risk quietly replace words like misunderstanding. Because institutions, especially old ones, don't panic. They observe. And according to multiple sources familiar with internal palace operations at the time, something shifted in the final months before Meghan Markle and Prince Harry's departure from the UK. Not dramatically, not publicly, but in a way that was unmistakable to the people who worked inside those walls every day. Phone calls rerouted, conversations compartmentalized, staff advised, informally, almost casually, to document interactions more carefully. Nothing accusatory, nothing explicit, just caution. Now, pause there for a second. Ask yourself, when does an institution as practiced, as controlled, as risk-averse as the British monarchy begin quietly preparing for legal exposure? Not for scandal, not for embarrassment, for liability. That's the question that keeps surfacing as we trace this story backward. Because the allegations that have emerged, again, allegations, not findings, don't describe a couple scrambling after the fact. They describe preparation. They describe something insiders sometimes refer to as legal insurance. And legal insurance isn't about winning a case. It's about never being cornered. According to a bombshell report now circulating among legal analysts and intelligence observers, Meghan Markle allegedly retained a US-based private intelligence firm during her final months in the United Kingdom. Not to brief the press, not to conduct opposition research in the tabloid sense, but to quietly collect information on palace staff, aides, assistants, people without platforms. Why them? Hold that question. We'll come back to it. What matters right now is timing. Because if this allegation is accurate, even partially, then the intelligence gathering didn't follow the public fallout. It preceded it, and that changes the entire frame. It suggests that the exit narrative, the interviews, the legal posture that followed weren't improvised responses to mistreatment. They may have been the final act of a strategy already in motion. That doesn't make the claims true, but it makes them serious. And seriousness is something this story has often been denied. For years, coverage around Meghan Markle has swung between extremes: adoration and vilification, empowerment and persecution. The noise has been relentless. So loud, in fact, that quieter questions were drowned out. Questions like, why would an American intelligence firm be involved at all? Why operate across borders? Why focus on staff instead of principals? Why gather information that never appeared publicly? And perhaps most unsettling of all, why did the palace respond not with outrage, but with restraint? Because if someone inside a monarchy believes they're being surveilled, the expected response isn't patience. It's escalation. Yet that didn't happen. What happened instead, again, according to those familiar with internal deliberations, was something colder. Containment. Not confrontation. Not exposure. Containment. And containment only makes sense if exposure carries risk. This is where the story stops being about personality and starts being about power. Because information is power. And in modern legal conflicts, power doesn't always announce itself. It accumulates quietly, stored in documents, messages, timelines. And who said what, when, and under what pressure. That's what intelligence firms do. They don't chase headlines. They chase leverage. Now, before we go any further, it's important to be clear about what this story is not. This is not a verdict. This is not a prosecution. This is not a claim of guilt. It is an examination of allegations and the behaviors that surround them. And in investigative reporting, behavior often matters as much as evidence, sometimes more. Because behavior tells you what people are afraid of, and fear leaves patterns. One of the most persistent patterns in this story is the decision, allegedly, to operate from the United States. Why not the UK? On the surface, it might seem logistical. Meghan Markle is American. US-based firms are familiar. Jurisdictional comfort. But intelligence professionals see something else. Distance. Legal insulation. Plausible deniability. Cross-border operations complicate oversight. They blur accountability. They create layers, intermediaries, contractors, legal buffers that make direct attribution difficult. That doesn't prove intent, but it suggests foresight. And foresight is rarely accidental. Another pattern, the focus on palace staff rather than senior royals. This is one of those details that seems minor until you sit with it. Staff members don't control policy. They don't issue statements. They don't have constitutional authority, but they do see everything. They hear conversations that aren't scripted. They witness reactions that aren't rehearsed. They absorb tensions before they're sanitized. And in legal disputes, witnesses matter more than figureheads. Staff also share something else. Vulnerability. They don't have media teams. They don't have public platforms. They don't have armies of defenders online. If information is power, staff are pressure points. Again, this doesn't confirm wrongdoing, but it does reveal logic. And logic is what separates conspiracy from strategy. What makes this story particularly difficult to dismiss is what didn't happen. No leaks. No exposés sourced directly to staff. No sudden revelations attributed to anonymous aides. If intelligence was gathered, it wasn't weaponized publicly. At least not yet. Which raises a more troubling possibility. What if the information was never meant to be released at all? What if its purpose was deterrence? In legal circles, there's a phrase that comes up again and again when discussing high-stakes disputes: mutually assured destruction. The idea isn't to strike first. It's to ensure the other side never does. If that sounds extreme, consider the stakes. An ancient institution facing reputational collapse. A global celebrity facing credibility erosion. Legal actions spanning continents. Narratives competing for legitimacy. In that context, silence can be more powerful than exposure. And the palace's silence has been extraordinary. For years, many assumed it was weakness, or confusion, or outdated protocol struggling in a modern media environment. But what if it was something else? What if silence was the price of stability? This is where King Charles enters the frame, not as a character in a family drama, but as a risk manager. Because monarchs don't rule through emotion. They rule through continuity. And continuity depends on minimizing variables. According to sources close to palace decision-making, there came a point where reconciliation was no longer the primary objective. Containment was, not because of personal grievances, but because of institutional exposure. And that leads us to the word that keeps resurfacing in private briefings and off-the-record discussions: permanent. A permanent ban is not punishment. It's not retaliation. It's not moral judgment. It's a firewall. If you believe that ongoing proximity increases risk, you don't negotiate sentiment. You reduce access. And access, in this case, is everything. Now, here's where the story tightens. Because if there was intelligence gathering, again, allegedly, it raises a question that no one has fully answered. Why now? Why do these reports surface years later, when public interest has ebbed and narratives feel settled? Timing is never neutral. Legal leverage expires. Documents age. Witnesses move on. Unless something changes. Unless the balance of risk shifts. Unless silence is no longer sustainable. That's why this story matters now. Not because it rehashes old wounds, but because it reframes them. It asks us to reconsider whether what looked like chaos was actually choreography. Whether emotional public moments were the visible edge of something far more controlled beneath the surface. And whether the most consequential actions were never meant to be seen at all. So as we move forward, here's what we won't do. We won't rush to conclusions. We won't collapse complexity into slogans. We won't pretend certainty where there is none. What we will do is follow the logic, the timelines, the incentives, the behaviors. Because when you strip away personalities, the patterns become harder to ignore. And the first pattern, the one that sets everything else in motion, is the moment the palace stopped reacting and started preparing. Because once that happens, the story is no longer about what was said. It's about what was anticipated. And in the next section, we're going to look closely at that exact moment, the point at which internal caution quietly replaced trust, and why some inside the palace now say they knew something was coming long before the public ever did. And once you see that moment clearly, it becomes very hard to see what followed as accidental. There's a point in every institutional crisis when the noise fades, not because the situation is resolved, but because the people in charge stop reacting emotionally and start measuring consequences. According to multiple individuals familiar with palace operations during that period, that moment didn't arrive with an argument or a public confrontation. It arrived quietly, almost politely, in the form of small, procedural shifts that most outsiders would never notice. Nothing dramatic. No emergency meetings splashed across calendars. No furious emails. No sudden firings. Just a narrowing. Conversations that used to happen in hallways were redirected into offices. Phone calls that once felt informal suddenly had witnesses. Staff were gently reminded to loop in others, to keep notes, to be mindful. Those phrases sound harmless, bureaucratic, even dull. But anyone who's worked inside a sensitive institution knows exactly what they mean. They mean the environment has changed. And what's striking is how early that change appears to have occurred. Not after the exit, not after the interviews, not after the lawsuits. Before. That's the part that doesn't sit comfortably with the popular timeline. Because the public narrative suggests a palace caught off guard, scrambling to respond to allegations after they exploded into the open. A reactive institution, slow-footed and outdated, struggling to control a modern media firestorm. But inside the building, the mood was different. More cautious, more deliberate, less surprised. One former aide, speaking anonymously, described it this way. It wasn't panic. It was tightening, like doors closing softly. That distinction matters. Panic leads to mistakes. Tightening leads to containment. And containment suggests anticipation. Now, anticipation of what? That's where things become uncomfortable. Because the palace wasn't bracing for gossip. They've survived that for centuries. They weren't bracing for tabloid storms. Those are seasonal. What they appeared to be bracing for, again, according to those familiar with the internal climate, was legal exposure. Not a lawsuit filed tomorrow, but a narrative that could become evidence later. That's a very different threat. It's one thing to manage headlines. It's another to manage records. When an institution begins advising staff to document interactions, to clarify instructions in writing, to avoid ambiguity in tone and language, it's not doing so for optics. It's doing so because someone, somewhere, is thinking ahead. And here's the question that deserves to be asked plainly, without melodrama. Why would the palace believe it needed to protect itself legally from people inside its own walls? That's not normal. That's not routine. That's not standard crisis management. Something prompted it. What's especially revealing is who these precautions applied to. Not senior royals, not public-facing officials, but staff, administrative aides, communications assistants, scheduling coordinators, people whose names never appear in press releases, people who, under normal circumstances, operate on trust. Trust that conversations are internal. Trust that misunderstandings will be resolved quietly. Trust that loyalty flows both ways. When that trust erodes, documentation becomes the substitute. One staffer described being advised, informally, not in writing, to assume everything could be reviewed later. Reviewed by whom? That question was never answered. And perhaps that was the point. Because ambiguity creates compliance. Now let's slow down here. This isn't evidence of wrongdoing. It isn't proof of surveillance. It isn't confirmation of intent. But it is evidence of mindset. An institutional mindset that had shifted from relationship management to risk management. And that shift didn't happen overnight. Several sources place it in the final stretch of Meghan Markle's time in the UK, months before the official announcement of departure. When public appearances continued, smiles were photographed, and the surface narrative still held. That's the part that feels unsettling. because it means two stories may have been unfolding simultaneously. One visible, one invisible. On the surface, duty, appearances, tension framed as personality clashes. Underneath, quiet preparation. And preparation has fingerprints. One of those fingerprints is compartmentalization. Staff who previously worked across multiple areas suddenly found their access narrowed. Not revoked, just limited. Meetings became more structured. Fewer off-the-record conversations. More people copied on emails. Again, nothing accusatory. Nothing that could be pointed to as evidence of distrust. But enough to change behavior. Another fingerprint is language. People close to the process recall a noticeable shift in tone. Less warmth. More neutrality. Instructions framed carefully, almost legally. Phrases like, for clarity, for record-keeping, to avoid confusion. When language changes, it's because someone is imagining a future audience. And that audience wasn't the press. It was legal. Here's where we need to ask something directly. If you were inside an institution and believed there was a possibility, however remote, that information was being collected on you, how would you respond? Would you confront it publicly? Or would you quietly reduce exposure? Public confrontation escalates. It creates records. It invites scrutiny. Quiet containment does the opposite. It limits data. It narrows variables. It buys time. That appears to be what happened. Because what didn't happen is just as telling. There were no internal accusations. No leaks accusing anyone of spying. No disciplinary actions that hinted at misconduct. Silence, but not ignorance. One legal advisor, speaking on background, described the palace's posture during that period as observational. Not passive, observational. Watching patterns, tracking inconsistencies, measuring risk. This is where many casual observers get lost, because we're conditioned to look for explosions, for confrontations, for dramatic turning points. But institutions like this don't explode. They calcify. They narrow options. They harden boundaries. They stop improvising. And when improvisation stops, it's because someone believes the margin for error has disappeared. Let's talk about margin for error. For palace staff, the margin for error is usually wide. Minor missteps are absorbed. Miscommunications are smoothed over. Loyalty is assumed. But in this case, the margin shrank. Staff began to feel it in small ways. A conversation that would normally be brushed aside suddenly followed up with an email summarizing it. A casual remark met with a careful response. A request for clarification that felt unnecessary. These are not accusations. They're indicators. Indicators that someone, somewhere, was thinking, how would this read later? Later in court? Later in arbitration? Later in a legal brief? Those questions don't arise spontaneously. They arise when legal exposure is perceived as plausible. Which brings us back to the core contradiction. If the palace truly believed it had nothing to fear, no exposure, no vulnerability, why prepare at all? And if it did believe there was risk, where did that belief come from? That's the part of the story that hasn't been openly addressed. Because it points not to a single incident, but to a pattern of concern. A sense that interactions were no longer purely interpersonal, but potentially evidentiary. That's a chilling shift in any workplace. Especially one built on hierarchy, discretion, and long-standing norms. Now, here's where we need to be careful. It would be easy to jump to conclusions. To assume that preparation equals guilt, or that caution equals confirmation of surveillance. That's not how serious analysis works. Caution can be precautionary. Preparation can be defensive. Institutions prepare for contingencies all the time, but they don't do it randomly. They do it when signals accumulate. Signals like increased legal consultation, unusual interest in documentation, heightened awareness of messaging consistency, and perhaps most telling of all, restraint. Because if someone believed they were being wronged and wanted to expose it, they would act. Publicly. Decisively. The palace did not. Instead, it absorbed. Which suggests the perceived risk of escalation outweighed the perceived benefit of confrontation. That calculation is rare, and it implies that whatever the palace believed might exist, whatever information might have been gathered or might be gathering, was serious enough to warrant caution. Let's pause again and ask something uncomfortable. Have you ever noticed how often the most powerful responses are the ones you never see? No press release, no rebuttal, no denial, just distance. Because distance reduces risk. And distance was exactly what followed. Gradual distancing, controlled access, eventual separation. Not impulsive, not emotional, administrative. By the time the public narrative framed the departure as sudden, insiders describe it as already processed, already accepted, already planned for, which raises the question, planned by whom? And for what scenario? Here's where the idea of anticipation becomes unavoidable. Because you don't prepare documentation unless you expect scrutiny. You don't narrow access unless you believe access itself is a liability. And you don't quietly tolerate uncertainty unless the alternative is worse. That's the logic. And logic doesn't care about personalities. It cares about outcomes. So when people talk about the palace being caught off guard, it's worth asking. Off guard by what? The publicity? Maybe. The legal implications? Unlikely. Because by the time the story went public, the palace had already adjusted, already contained, already drawn boundaries that would later harden into something far more final. Which brings us to the next layer of this story. Because internal caution doesn't emerge in a vacuum. It emerges in response to perceived action. And in the next section, we're going to examine what may have triggered that perception, the concept of legal insurance, how it operates in high-stakes exits, and why some inside the palace believe the preparation they witnessed wasn't paranoia at all, but recognition. Recognition that the conflict ahead wouldn't be fought in public. It would be fought in documentation. And once that realization set in, everything changed. What does it mean to plan for a conflict that hasn't happened yet? Most people imagine preparation as a simple checklist. Contracts reviewed, statements drafted, meetings scheduled. But in high-stakes situations, especially when global attention, legal exposure, and personal reputations intersect, preparation takes on a more complex, almost surgical form. It isn't reactive. It is anticipatory. And it can blur the line between defense and offense. In the case of Meghan Markle's final months in the UK, according to multiple sources and reports, this anticipatory strategy is being referred to as legal insurance. The phrase is precise and deliberate. It's not dramatic, not sensational, it's methodical. Legal insurance is a concept most of us encounter abstractly. We think of it as a safety net, something dormant until needed. But in the world of high-profile legal planning, it's more than that. It's an ongoing mechanism to collect, protect, and strategically deploy information. Its goal isn't simply to win a case. It's to ensure that if the case is ever filed, you're never cornered. Which raises the first uncomfortable implication. If legal insurance exists, and if it involves gathering intelligence on staff, then the question isn't whether something might be used in court. It's whether it was meant to influence behavior long before any courtroom drama. Let's slow that down. Think about it. Collecting information quietly about people who are not parties to the dispute and maintaining that information in a form that could later be weaponized or leveraged, it is preemptive. It's anticipatory. It's strategic. And yet, this strategy has an emotional dimension that is easy to overlook. On one hand, it's logical, procedural, almost cold. On the other, it's deeply invasive. It's a paradox that sits at the heart of this story. Preparation as protection versus preparation as power. Sources indicate that this strategy, if accurate, was not ad hoc. It didn't begin in the weeks immediately preceding public exits or interviews. It began months in advance. Small, discrete steps. Subtle, almost imperceptible measures designed to secure leverage. The goal, as described by insiders, wasn't publicity. It wasn't revenge. It was the quiet accumulation of influence, evidence, and options before the first headline landed. And here's where the complexity deepens. Legal insurance in this context wasn't just about potential court filings. It was about positioning, anticipating every scenario, the interviews, the media coverage, potential staff statements, the eventual negotiation of titles, security arrangements, and public perception. Each move calculated not just for legal survival, but for control of the narrative. This is what separates casual observers from those who understand the machinery behind high-profile exits. A typical response to a crisis might involve hiring a PR firm, issuing statements, or managing immediate fallout. Legal insurance, by contrast, exists in parallel, quietly, strategically, systematically. Its purpose is to ensure that any future dispute, real or potential, can be managed not through improvisation, but through prepared leverage. Now, consider the human dimension of this. Staff, for instance, are usually not adversaries. They are witnesses. They are assistants. They are individuals whose proximity to information makes them central, though invisible, actors in legal strategy. Collecting intelligence about them is not about targeting individuals for wrongdoing. It is about anticipating what information they might possess and how it could be used if the dispute escalates. The ethical implications are profound. And here's the tension. If this intelligence gathering occurred, it was framed not as offensive, but defensive. Yet the effect is inherently coercive. Those observed, unaware they are under scrutiny, might unwittingly become pawns in a larger strategy. It's an uneasy paradox. Defense becomes power. Protection becomes leverage. And in that gray zone, perception often outweighs reality. Sources familiar with such operations describe a process that is deliberate, layered, and insulated. Often, the firm contracted would operate across borders, adding distance, both legal and procedural, between the intelligence gathered and those commissioning it. This isn't incidental. The US-based firm, allegedly engaged in this scenario, would provide jurisdictional separation. Documents, communications, and internal reporting could remain outside direct UK oversight. Plausible deniability is built into the framework. For the palace, this represents a unique challenge. If intelligence is being gathered discreetly outside the UK, it exists beyond the immediate reach of institutional control. Even senior advisors may not know the full scope. Staff may be unaware they are observed. And yet, the palace must respond to the possibility of exposure. That is the pressure point that defines this alleged strategy. Anticipation drives action even before events materialize. Pause for a moment and consider the psychological toll. Staff in such environments, highly skilled, loyal, yet suddenly aware that their interactions might be documented, experience an invisible shift. Trust is eroded subtly. Conversations are curated. Actions are measured. The institution's protective posture inadvertently creates internal tension, even without public disclosure. And that tension is precisely why legal insurance, in its most effective form, works silently. It doesn't demand confrontation. It doesn't issue threats. It simply exists as a structural hedge against unpredictability. Let's be clear, this isn't conspiracy. This isn't the sensationalized version of spying or plots. It is legal strategy. It is risk management. It is the methodical calculation of contingencies, an attempt to ensure that when conflict arises, you have options, evidence, and leverage. And yet, despite the careful planning, leaks and reports have begun to surface. The very existence of these allegations is enough to reignite public curiosity. Because the story isn't about whether legal insurance is immoral, it's about its implications when applied in a high-profile, politically sensitive, and globally scrutinized environment. Which brings us back to the essential question: why now? Why are these reports emerging after the fact? Timing, in these cases, is rarely accidental. Documents age, witnesses move, contracts expire, public attention shifts. But sometimes a threshold is crossed, and the information, or at least the allegations about its existence, can no longer remain dormant. And when that happens, the palace faces a dual challenge. Not only must it manage its external reputation, but it must also contend with internal perception. Staff who may have been observed, consciously or unconsciously aware of scrutiny, now exist in a landscape shaped by both prior strategy and current narrative. Consider the delicate balance. Acting too aggressively could validate rumors. Ignoring it could signal vulnerability. Every choice is constrained. Every action has consequences. Which is why, according to insiders, restraint became the guiding principle. Not indifference, not weakness. Restraint. Observing patterns. Monitoring developments. Preparing contingencies. Calculating outcomes. And it is precisely in that restraint that the next layer of the story emerges. Because legal insurance is not just about defense. It is about leverage. It is about influence. It is about ensuring that when confrontation occurs, if it ever occurs, it does so on your terms, within boundaries you've defined, and with options that others do not see. That, in turn, is why the palace's silence has been both notable and unsettling. To the outside observer, a lack of response might appear like compliance, confusion, or inefficiency. Internally, however, it may represent calculated containment, a recognition that the observed pattern, the intelligence quietly gathered, and the potential exposures were more manageable when approached cautiously. Pause for a moment and reflect. If this strategy, as alleged, unfolded exactly as sources describe, it paints a picture not of reactionary chaos, but of anticipatory calculation. The palace is not simply responding. It is positioning, waiting, calculating, which is where the moral tension lies. Legal insurance, by design, protects those who plan it. It creates certainty for the planner at the expense of unpredictability for others. And in environments as intimate and hierarchical as palace staff, the tension between personal loyalty and institutional duty becomes acute. Yet, despite the discomfort, this is what legal strategy looks like at the highest levels. The separation of personal and procedural stakes is not easy. The ethical ambiguity is unavoidable. And the consequences, if this information were to surface publicly, extend far beyond simple perception. It's an uneasy realization, one that sits at the edge of the story we're tracing. Preparation, when done quietly, can appear invisible, but its effects ripple, subtle and profound, throughout every interaction. And that leads to the cliffhanger of this chapter. What exactly was being gathered, and how specific was it? Because legal insurance only works when it targets the right variables. And in the next chapter, we'll examine the focus on staff rather than royals, why proximity matters more than authority, and what that tells us about the logic driving this alleged operation. There's a reason serious investigators pay attention not just to what is done, but where it's done from. Jurisdiction isn't a technicality. It's a strategy. So when reports suggest that any private intelligence work connected to this story, again, alleged, unproven, and still opaque, was handled by a U.S.-based firm rather than a UK one, it raises a question that goes far beyond convenience. Why operate at a distance? At first glance, the answer seems simple. Meghan Markle is American. Her legal team is largely American. Her professional network is rooted in the U.S. So naturally, if outside consultants were ever involved in any preparatory work, one might expect them to come from that same ecosystem. But intelligence professionals see something else layered beneath that logic. Distance creates insulation. Not just geographical, but legal and procedural insulation. Different disclosure rules, different oversight standards, different thresholds for subpoena and discovery, different relationships between private investigators and the courts. In other words, different levels of visibility. And visibility is everything when the issue isn't public relations, but potential evidence. Let's be precise here. We are not talking about spying in the cinematic sense. We are talking about the broad category of private intelligence and investigative services that operate legally, quietly, and often at the intersection of law, corporate risk, and reputation management. These firms don't break into offices. They don't wiretap phones. They don't operate like rogue agents. What they do legally is collect open-source intelligence, conduct background research, map networks, analyze communications patterns, and compile dossiers based on public, semi-public, and voluntarily provided information. They also know how to structure that information so it can be used later. Not in headlines. In legal contexts. That's the part that matters. Because if any such firm was engaged in the final months before a highly sensitive institutional break, the choice of jurisdiction would not be incidental. It would be part of the architecture of protection. Protection from what? From premature exposure. From discovery. From being compelled to reveal methods or sources. In the UK, private investigators operate under a different regulatory culture. There is a long-standing, close relationship between press, investigators, and the courts. The memory of past scandals, phone hacking, unlawful surveillance, misuse of private data, has made the environment cautious, tightly monitored, and politically sensitive. Any investigative activity that even smelled like intelligence gathering inside the orbit of the monarchy would draw scrutiny. In the U.S., the landscape is different. The private intelligence sector is larger, more corporatized, more legally layered. Firms often work for multinational clients, operate through law firms, and structure their activities under the umbrella of litigation support, risk assessment, and compliance. The language is clinical. The processes are insulated. The paper trails are carefully managed. Again, none of this implies illegality. It implies forethought. And forethought, in this story, keeps resurfacing. Now, ask yourself something. If you believed, even as a precaution, that future legal disputes were possible, and that narratives, testimonies, and internal accounts might one day be contested, where would you want your preparatory work to reside? In the same jurisdiction as the institution you might be opposing? Or in a parallel system, buffered by distance and different rules? That's not a moral question. It's a strategic one. And strategy is what separates emotional reaction from institutional planning. What also matters is the structure of how such firms are typically engaged. They are rarely hired directly by individuals in sensitive cases. More often, they are retained through legal counsel or through corporate entities acting on behalf of clients. This creates layers, firewalls, really, between the subject, the intelligence gatherers, and any potential scrutiny. Layers that complicate attribution. Layers that protect confidentiality. Layers that ensure that, if questioned, the answer is procedural, not personal. This is what people mean when they talk about plausible deniability. Not deception, necessarily, but distance. And distance changes dynamics. For palace staff, the idea that any form of external intelligence work could be occurring beyond UK oversight would be almost impossible to verify. They wouldn't see it. They wouldn't feel it directly. They would only sense its possibility through the behavioral shifts we discussed earlier: documentation, caution, narrowed communication. That's how indirect pressure works. It doesn't announce itself. It alters the environment. Which brings us to another subtle point. If any preparatory intelligence work existed, it would not have been about dramatic revelations. It would have been about patterns. Who speaks to whom? Who holds which responsibilities? Who might later be called upon as a witness? Who has institutional memory? And who has grievances? These are not secrets. They are structures. And mapping structures is what intelligence analysis does best. This is why the alleged focus on staff, rather than senior royals, becomes more intelligible when viewed through this lens. Senior figures are public. Their statements are on record. Their roles are defined. Their exposure is constant. Staff, by contrast, are repositories of context. They understand how decisions are made, how conflicts evolve, how narratives are shaped internally before they become public. In legal disputes, context can be as powerful as fact. So if any firm was tasked with understanding context, it would look not at authority, but at proximity. Proximity to conversations. Proximity to processes. Proximity to moments that never make it into official minutes. Again, we are not asserting that this happened. We are examining why, if it were alleged to have happened, the logic would point in this direction. And that logic, uncomfortably, is coherent. Now consider the palace's position. If they suspected, even faintly, that information about internal processes, staff dynamics, or informal communications might be compiled externally, their response would not be to accuse. It would be to reduce the informational surface area. Fewer people in meetings. Clearer chains of communication. More formal documentation. Not because they had proof, but because they were minimizing variables. This is where the story becomes less about individuals and more about systems reacting to perceived risk. And systems, unlike people, don't act out of emotion. They act out of probability. Probability that something could be misinterpreted. Probability that something could be selectively presented. Probability that something could one day appear in a legal filing or a sworn statement. So they prepare. They tighten. They go quiet. And the choice of a U.S. base for any alleged intelligence activity would, in that context, make strategic sense. It would place the preparatory work in a parallel legal universe, close enough to be useful, far enough to be insulated. Which leads to a deeper, more unsettling question. If the palace was adjusting its behavior in anticipation of potential legal and narrative exposure, and if any external intelligence preparation was occurring simultaneously, were these two processes aware of each other? Not coordinated, not acknowledged, but mutually sensed. That's the kind of silent standoff that never becomes public. Not because it isn't real, but because acknowledging it would escalate it. And escalation is exactly what both sides would want to avoid, at least until they were ready. This is the space in which legal insurance operates, not in open conflict, but in parallel preparation. Each side, assuming the other is thinking ahead. Each side, quietly reinforcing its position. And all of it happening beneath the surface of public life, where the narrative still looked emotional, chaotic, even impulsive. Which brings us to the next layer. Because the choice of jurisdiction and the logic of distance only answer part of the puzzle. The more revealing question is not where any alleged intelligence work was based, but who it focused on. Not the figures in the spotlight, not the ones with titles, but the people in the corridors, the assistants, the aides, the staff whose voices are rarely heard, but whose knowledge is intimate. And in the next section, we're going to examine why, in any serious preparatory strategy, those voices would matter more than anyone else's. Because proximity, in the end, can be more powerful than rank. And if that's true, then the center of gravity of this story isn't where most people have been looking. It's been somewhere much quieter. There's another reason distance matters, and it has nothing to do with paperwork or jurisdiction. It has to do with psychology. When people know they are being watched, they change. When they suspect they might be, they change even more. But when the possibility of observation exists without confirmation, when it hovers as a rumor, a suspicion, an unprovable feeling, that's when behavior becomes most cautious. Because uncertainty is a powerful regulator. Inside institutions, especially hierarchical ones, uncertainty creates self-discipline. Conversations become careful. Jokes disappear. Tone flattens. Everyone starts choosing words as if they might one day be read aloud by someone who wasn't in the room. That's not paranoia. That's risk management at the human level. Now imagine that uncertainty is tied not to internal monitoring, but to the possibility, however remote, of external documentation. Of conversations, dynamics, conflicts being reconstructed later by people who were never present. That changes everything. And that is precisely why the idea of a US-based intelligence firm operating at arm's length becomes so significant in this story. Not because such a firm could see more, but because it could see differently, from the outside, without the cultural filters of the institution, without the internal loyalties, without the assumptions that come with long service. An external intelligence analyst doesn't ask, is this appropriate within palace culture? They ask, how would this read in a legal context? How could this be interpreted under oath? What patterns emerge across time? That kind of analysis strips away nuance and focuses on structure. And structure is what courts care about. Patterns of behavior, chains of communication, consistency of testimony, gaps in records. So when people question why any preparatory work would be based in the US, the deeper answer may be this: because the US legal and intelligence environment is built to think in terms of future litigation, even when no case yet exists. It is pre-litigation culture. Everything is potentially discoverable. Everything is potentially contestable. Everything is potentially leverage. Now, take that mindset and apply it to an environment like the palace, where tradition, discretion, and informal norms have historically carried enormous weight. You suddenly have two systems of thinking colliding, one built on centuries of custom and internal resolution, the other built on documentation, adversarial process, and strategic foresight. That collision doesn't need to be dramatic to be profound. It only needs to exist. And if it did, even as a possibility, it would explain a great deal about the palace's quiet shift toward formality, documentation, and procedural caution in those final months. Not because anyone had proof of wrongdoing, but because they were adjusting to the logic of a different game. A game in which silence could be safer than rebuttal, in which distance could be safer than proximity, in which containment could be safer than confrontation. There's another subtle layer here. US-based private intelligence firms often operate in tandem with legal teams. Their work can be framed as attorney-client privileged. Their reports can be structured as litigation support. Their communications can be shielded, to varying degrees, from disclosure. Again, this is not about illegality. It is about architecture. Architecture designed to ensure that, if questions are ever asked, the answers are filtered through legal process before they are public. From the palace's perspective, that architecture would be nearly impossible to penetrate. You can't respond to what you can't see. You can't challenge what you can't access. You can't correct what you don't know exists. So you prepare for the possibility instead. You reduce exposure. You formalize interactions. You assume that anything said casually today could be read critically tomorrow. This is what institutions do when they sense asymmetry. And asymmetry is the core of this chapter. An asymmetry of jurisdiction. An asymmetry of legal culture. An asymmetry of preparation. If one side is thinking in terms of narrative and relationship, and the other is thinking in terms of record and leverage, the playing field is no longer even. That doesn't make either side villainous. It makes them different. And difference, in legal contexts, creates risk. Which brings us back to the choice of a U.S. firm. Not as proof of intent, not as confirmation of action, but as an indicator of mindset. A mindset that anticipates scrutiny before it arrives. That prepares for disputes before they are declared. That treats information not as story, but as asset. And when information becomes an asset, the question is no longer simply what is true. It is who controls the framing of truth. Now, here's the quiet, unsettling implication that lingers. If any intelligence preparation was indeed taking place beyond the palace's jurisdiction, then the palace's later posture. Its restraint, its refusal to engage in public back and forth, its eventual decision to draw firm, permanent boundaries, may not have been emotional at all. It may have been strategic, not in response to what had been said, but in anticipation of what could one day be presented. And that anticipation, once it exists, changes how institutions behave forever. They stop assuming good faith. They start assuming future scrutiny. They don't argue. They insulate. They don't escalate. They narrow. Which leads us directly to the next, and perhaps most revealing, question. If any such preparatory work existed, and if it was structured to anticipate legal and narrative conflict, then it would not have focused on those with the most power. It would have focused on those with the most proximity. The people who heard things before they were polished. The people who saw tensions before they were reframed. The people who could, one day, be asked to recall what really happened. In other words, the staff. And in the next chapter, we're going to look closely at why, in any serious strategy of legal insurance, palace staff would become the quiet center of gravity, and why that focus, more than anything else, may explain the unease that settled over the institution long before the public ever sensed it. Institutions crumble from the edges, not always from the center. That's a lesson historians, organizational theorists, and intelligence analysts alike have observed time and again. And in the case of the palace, the edges, the people closest to the machinery but farthest from titles, may have been where the pressure quietly concentrated. It's counterintuitive at first. Why focus on staff rather than the principals? After all, senior royals are the face of power. Their statements are public. Their actions are documented. They wield authority. But that visibility is also a limitation. Public figures are predictable. Their routines are observable. Their channels of communication are known. Staff, however, occupy the shadows between the public and the private. They know the informal conversations, the reactions before they're edited for public consumption, the sequences of decisions that never leave a memo. They witness patterns, record context, and remember the discrepancies that later become important. Consider the role of a private secretary or an assistant managing calendars. Their work seems mundane. But in reality, it is a living map of access, priorities, and interactions. Who meets whom? Who is kept in the loop? Who receives sensitive information first? And who is excluded? These are not just administrative choices. They are signals. They reveal influence and trust networks within the institution. If intelligence is being gathered in anticipation of legal or narrative conflict, staff are the natural focus. Not because they are culpable or adversarial, but because they hold the patterns of truth. They are repositories of institutional memory, sometimes unrecorded elsewhere. And in disputes where recollection matters, the memory of these individuals can be decisive. Pause and think about that for a moment. If someone wanted to create leverage, not by attacking, but by safeguarding potential claims, staff are the logical starting point. They are the conduits through which knowledge flows. They are the witnesses whose testimony can validate or undermine narratives. Sources familiar with palace operations during this period describe a subtle but persistent shift in behavior. Meetings were increasingly documented. Instructions were clarified in writing. Staff were advised, gently but unmistakably, to keep precise records. Nothing accusatory, nothing alarming, but enough to create a culture of meticulous observation. Why is this significant? Because in any legal strategy that anticipates conflict, documentation is currency. The more structured and precise the internal records, the more reliable the leverage that can be exercised later. In other words, staff behavior is both the target and the measure of preparation. And yet, this focus is not necessarily visible to the staff themselves. Most never knew, or suspected, that their routine interactions were being mapped, analyzed, or preserved for potential future reference. The effect was cumulative, quiet, and profound. It altered everyday dynamics, subtly but unmistakably. Think of it as a form of indirect influence. You don't need to intimidate or confront someone directly if they already believe their actions may be scrutinized. Caution becomes self-regulated. Words are measured. Conversations are filtered. Patterns shift without anyone needing to intervene openly. There is another layer here. Proximity amplifies relevance. Those who are closest to power, not necessarily those with power themselves, can witness moments that reveal inconsistencies, tensions, and decisions that later become pivotal. Senior royals, by contrast, are observed constantly. Their statements and actions are public. They are managed, mediated, rehearsed. Staff are where the unvarnished reality exists. And this is precisely why any intelligence strategy, if it occurred, would emphasize staff. The goal is not to antagonize, but to understand the information landscape fully. Who knows what, when, and how they might recount it. And if the stakes are high, titles, reputation, legal exposure, that information becomes critical. The implications for palace dynamics are enormous. Even without active surveillance, the mere perception of observation can recalibrate behavior. Staff may become more cautious, less candid, more formal. They may second-guess interactions they previously considered routine. The internal climate shifts. The institution adapts, subtly but persistently. Now consider the psychological dimension. Staff are loyal, accustomed to discretion, and trained to prioritize the smooth functioning of operations. But in an environment where legal insurance is quietly being applied, their awareness, or even partial awareness, creates tension. The balance between trust and prudence becomes fragile. Employees start to measure not just outcomes, but perceptions. And yet, none of this is overt. There are no memos accusing anyone of wrongdoing, no directives instructing staff to alter behavior. The influence is indirect, a kind of gravity that reshapes patterns over time. Pause here and reflect. This is not about conspiracy. It is not about malicious intent. It is about structural leverage. It is about understanding who holds knowledge, how it flows, and how it could be used if circumstances shift. Staff, by definition, are the silent carriers of institutional memory. They do not have authority, but they carry context. They do not write headlines, but they preserve the sequences that make narratives credible or disputable. They do not appear in public statements, but they can validate or contradict them. And that's precisely what makes them central in this scenario. Allegedly, because if intelligence, or even the anticipation of intelligence, is focused on staff, it explains why the palace reacted with quiet caution rather than dramatic confrontation. You don't escalate against potential witnesses. You insulate against uncertainty. You reinforce process. You formalize access. You contain variables. And all of this, quietly, reshapes the institution, not in visible ways, not in headline-grabbing ways, but in the underlying logic of operations. It's an uncomfortable realization. Power isn't always about titles. It is often about proximity, access, knowledge. And in any legal or strategic preparation, these become far more critical than authority alone. Which brings us to the next layer, timing. Why did these shifts, these patterns of caution, documentation, and narrowed access, emerge when they did? Not after headlines broke, not after interviews aired, but during the final months in the UK? What triggered the perception that legal insurance might be necessary? The answer, in part, lies in the compressed timeline of the exit. But the deeper answer lies in anticipation, the recognition that even small missteps, unrecorded moments, or unguarded statements could later have outsized consequences. And that, in turn, is why the next chapter, the final months in the UK, a compressed timeline, is so critical. Because it is within that narrow window that preparation, perception, and strategy converged. The moments that seemed routine at the time were, allegedly, the very moments being mapped, documented, and quietly assessed. Time compresses differently under pressure. Days, weeks, months, they lose their usual sense of linearity when high-stakes decisions are looming, when exits are planned, and when the margins for error are vanishingly small. That, according to sources familiar with palace operations and the final UK months of Meghan Markle's tenure, is exactly what occurred. On the surface, the world saw a couple attending events, fulfilling appearances, and smiling for photographs. Charitable engagements proceeded. Public schedules remained intact. Interviews and media interactions were routine, as they always had been. Nothing appeared unusual. But inside, according to insiders, the internal clock had accelerated. Every interaction, every conversation, every note could carry consequences far beyond what was immediately visible. Staff began observing each other more carefully. Managers tracked timelines with unusual precision. Instructions were clarified in writing, often reiterated multiple times. Meetings were structured with tighter controls, and casual interactions diminished. This compressed timeline is significant for two reasons. First, it magnified the effect of any intelligence-gathering efforts, if they occurred. In a shorter window, every documented observation becomes more meaningful because there is less time for context to dissipate. A single note, a single email, a single observation can be traced back with greater clarity. Second, compression heightened the sense of urgency across the palace. Decisions that might have been leisurely under normal circumstances became urgent. Legal teams, administrative staff, and advisors had to anticipate the future not in months, but in weeks, sometimes even days. This urgency influenced behavior. Emails were scrutinized, memos were more precise, and informal interactions were minimized. Inside the palace, this period was described by multiple sources as a phase of quiet calculation. It was not panic, but a deliberate acceleration of protocols and procedures. Every decision was filtered through a lens of potential scrutiny. Every action was considered in terms of future implications. The tension was subtle but pervasive. Staff felt it without fully understanding it. Routine instructions began to carry implicit messages. Document everything. Verify everything. Anticipate questions. Assume that what seems mundane today could be referenced tomorrow. This is where anticipation begins to intersect with legal insurance. If intelligence-gathering efforts were underway, the compressed timeline would have amplified their utility. Patterns could be observed and mapped before behaviors changed. Discrepancies could be noted while still relevant. Contextual knowledge would remain fresh, intact, and actionable. It also explains why palace responses appeared restrained externally. There was no overt confrontation, no dramatic leaks, no visible escalation. The institution did not act impulsively because it did not need to. By quietly tightening procedures and observing patterns, it was already positioning itself for the eventualities that could emerge once public attention intensified. Timing also matters in terms of narrative control. During these months, public statements and media coverage were carefully curated. Events were conducted with attention to optics. Interviews were scheduled, media inquiries were managed, and messaging was aligned with long-term objectives. But beneath the surface, the palace's internal operations were evolving at a faster pace, creating a dual-track reality, one that was public and performative, and one that was private, procedural, and anticipatory. This dual-track reality is essential to understanding how the final months functioned. It was a period in which perception and preparation were intertwined. Public smiles and handshakes masked a strategic undercurrent. Routine engagements and ceremonial duties coexisted with meticulous documentation and observation. Staff were aware, at some level, that things were changing, even if they could not articulate why. Another factor amplifying the compressed timeline was the convergence of multiple overlapping pressures: the announcement of departure, the orchestration of public messaging, and the finalization of legal arrangements. Each layer added constraints, narrowing options, and reducing the margin for error. Decisions had to be made quickly, with an understanding of potential downstream consequences. Sources describe a sense of inevitability during this period. The exit was not spontaneous. It had been planned meticulously, and the palace had been aware of the potential for strategic documentation, intelligence gathering, and legal positioning. By the time public announcements were made, much of the internal groundwork had already been laid, quietly but definitively. This phase also saw the crystallization of what some insiders refer to as contingency mentalities. Teams were prepared for multiple scenarios: media fallout, legal challenges, internal staff responses, and public scrutiny. Protocols were tightened. Access was narrowed. Instructions were formalized. Communications were monitored, though subtly, to ensure that nothing could later be misinterpreted or omitted. All of these measures contributed to a sense of compressed urgency. Staff were operating under an intensified temporal logic: anticipate, document, verify, repeat. Every action was considered through the lens of what could matter in the next day, the next week, or the next month. The pace of internal operations had accelerated beyond the visible pace of public events. And yet, despite this pressure, outward appearances remained calm. Official engagements continued. Charity work proceeded.